issues to do with the recent ruling with the Supreme Court. Also, many Ugandans of interest. And their biggest issue was what next and what are you doing about it as government. So I don't know if you have an update you can give us, and then we move on.
Thank you very much, Right Honourable Speaker. Right Honourable Speaker, a judgment was delivered on Friday in Supreme Court Constitutional Appeal
procedure.
number 2.
Attorney General, we have procedure.
Mr. Speaker, we are in a very complicated situation. The Attorney General is the one who wanted the military to try civilian. He is the one who went to court. He is therefore a party to this case. So the procedural issue I am raising is whether after his comment you will allow us, those who subscribe to the other party, also to make some comments, because he's a party. This one, Honorable Chiriowa, is the one who wanted the military to try with civilians.
Yeah, thank you. Two things. Number one, I don't look at him as a party to the case now. I look at him as a representative legal advisor of government who was given directives to implement by the court. So it's from that background. Now we are no longer having issues. The issues were settled at court level. Number two, Honorable, you know, I'm usually generous on such issues. This is part of my communication. I gave a colleague a chance to speak here. After speaking, I saw him on TV saying the speaker doesn't allow us to speak. So I wanted to drop him a call and say, but my brother, today you spoke 4 times in the house, and then you're now on TV saying the speaker doesn't allow us to speak. And when you're speaking, he said, no, I was the presiding officer that day. So, but it happens, eh? It's part of, we are in politics, we are in many things, but I will allow you, honorable colleagues, because I did this because of the many calls I received from colleagues. That's why I said, Honorable Attorney General, please.
Thank you very much, Right Honourable Speaker, for your wise guidance. Like I said, judgment was delivered on 31st January 2025. We received a signed judgment on Sunday, 2nd February 2025. We rendered advice dated 3rd February 2025. As you can see, the record speed. And we advised as follows, Right Honourable Speaker, that 1, all pending criminal trials in the General Court Martial should cease forthwith. 2, that the General Court Martial in liaison with prisons authorities should provide a list of all criminal cases involving civilians pending before the General Court Martial for onward transmission to the courts to determine the appropriate court to handle the matter. 3, the General Court Martial should provide a list of all pending criminal cases involving members of the UPDF pending before the court martial that fall within the categories of transfer for onward transmission to the courts for determination of the appropriate court to handle the matter. 4, the Director of Public Prosecutions is advised to liaise with the General Court Martial and the UPDF to take over the conduct of the ongoing criminal trials that have been identified for transfer. 5, the Uganda Prisons Authorities are advised to await the process above and orders of competent courts regarding any matters concerning detention of accused persons hitherto facing trial in the military courts. 6, the Ministry of Defense and Veteran Affairs is also advised to immediately commence consideration of the recommendations of the Supreme Court with a view to introducing appropriate amendments to the UPDF Act. Right Honourable Speaker and Honourable colleagues, I have also written to the Honourable the Chief Justice and requested the Honourable the Chief Justice to advising him that we have commenced the implementation of the court orders and sought for advice on the person with whom the DPP should liaise for purposes of effecting these orders. I thank you, Right Honourable Speaker.
Thank you. Thank you. Yes. No, I want all these issues will be handled in my, because it was part of my communication. Yeah. So we have one colleague here who was among the councils. So Honourable Segona.
Thank you, Right Honourable Speaker. First of all, I want to express gratitude to the Attorney General that he was able, unlike the tweets that we saw, which clearly said that these suspects, or some of them, would not be released, at least the Attorney General has indicated the willingness to have the court order implemented, notwithstanding, of course, instances where he must have read these orders upside down. Right Honourable Speaker and Honourable colleagues, as the Attorney General was communicating, I have been really touched and concerned about a number of issues. The Attorney General knows very well that a person can only be held in prison on a valid warrant. The order of court, which literally dismantled, and I mean literally, not technically, dismantled the orders of the defunct court-martial, caused the warrants upon which these people were remanded to expire. But in the case of retired Colonel Dr. Kizza Besigye and Hajj Obeid Kamlegea, even without the orders of the Supreme Court, the warrant itself was expiring on Monday, yesterday, and it did expire. So, my question to the Attorney General, currently for these people or persons that are being held, on whose orders, on whose valid warrants do they continue to be in prison? The second, Right Honourable Speaker, relates to the DPP liaising with the General Court Martial. What is the DPP's business? The DPP is empowered under the law to commence prosecutions against any person of her choice, provided there is evidence she has before her. The reverse is not true, that the DPP goes around fishing for cases. Number three, Right Honourable Speaker, but this time they are telling the DPP to be the one to go around fishing cases from persons that have been conducting business illegally. Do not forget that until Friday, 31st, there was a decision of the Constitutional Court which declared that this is not a court of law. So whatever they have been doing, they secured an interim order from the Supreme Court, and the order was to stay execution. Execution in this case was purely the transfer of files from the General Court Martial or from the Courts Martial to the civil courts. You could not stay a declaration. You can't stay a declaration. That declaration, that interim order, was used by the General Court Martial, not DPP, to continue and to commence fresh prosecutions. Thirdly, Right Honourable Speaker, from the Attorney General's communication, I have not even heard anything to do with timelines. Timelines, so as long as they are doing their consultations, these people can be in prison now on orders of the Attorney General. Where, under the law, does the Attorney General get the powers to remand or continue an illegal remand or to detain? Literally what he has done is to amend the orders of court. Finally, I received information from the Honourable Semuju.
Thank you very much, Honourable Medad. Thank you, Mr. Speaker. The information I wanted to give to Honourable Medad and Parliament is that yesterday our lawyers who represent Dr. Besigye and Hajj Obeid visited the Commissioner General of Prisons. And he said his understanding was that people needed to leave, Besigye and Ajobe needed to leave his prison on Friday when the judgment became effective. And he said he was there seated waiting for the Attorney General. Up to yesterday, the Attorney General had disappeared from him. The last time this happened, the last time people were in Ruzira on no warrant was after the fall of Idi Amin. I interviewed Brigadier Sewagala when I was a journalist. And he said they were driven to Ruzira and they were told, you go there, the warrant will come. So effectively, I didn't know that things that were done by Amin soldiers and after can be done by Honorable Chiwanuka Chiriowa almost 40 years later. That's the information I wanted to give you.
I thank you for the information, apart from the last one, which was not information, relating to what you did not know that Honorable Chiriowa Chiwanuka can do. Right, Honorable Speaker, I do not want to end at criticizing and critiquing my brother. I think I want to give some way forward. If I were in his unenviable position, this is what I would do. From Friday through to Monday, I would not sleep. I would require the information from the General Court Martial relating to all prisoners that are held on orders of the General Court Martial, now deceased. From that point, I would advise government to sieve out all political prisoners, matters which are not pure crime, and say, let us go and do the honorable thing of withdrawing. That someone can continue to be in prison, and the Attorney General is busy advising on somebody who was putting on a beret, a red beret, whether he should remain in prison. The third thing I would do, and for more than 4 years now, third thing I would do is to advise the police to immediately approach the General Court Martial, obtain all those files where we feel it is pure crime, a suspicion of crime, not suspicion of politics. Then I would advise that police would get those people from wherever they are upon release. But for you, you cannot say you are complying with the court order without releasing these people. At least do the ugly thing you've been doing of arresting them at the entrance or exit of the prison, the same way you've been arresting them from court. But any continuity in detention is illegal. Finally, I am concerned as a leader in this country. Immediately upon release of the judgment, Colonel Chris Magezi, who is said to be an assistant to General Muhoozi Kainerugaba, issued a statement which he called the official statement from the UPDF. And it was clear and categorical. They shall not be released until General Museveni, the commander-in-chief, gives us orders to release them. And that is the basis upon which we challenged the constitutionality of the court-martial, because it is dependent on orders of the chairman of the High Command, who is General Museveni. Membership includes his son, who is now tweeting to say we cannot release. Mr. Speaker, for how long are we going to continue like this as a country? You have a dignified Attorney General. That man knows the law, by the way. Even when he chooses to disobey or to ill-advise, at least he knows the law. Now, we receive another statement from the president. Half of it was dignified. The second half was very dignifying. You hear from the president, and what he says that this country is not governed by judges and lawyers, where I agree. But this country is governed by a constitution. Anybody who does not want to obey this constitution should give us our peace by leaving. I am concerned about the tweets of General Kainerugaba. You saw when he said that he was going to attack the mercenaries in Congo. A few days later it happened. How are our neighbors going to take us? You crack a war inside, you crack a war outside. Why? Is it the Constitution, Mr. Speaker?
Thank you. Hello?
Honorable Speaker, firstly, I'm glad that the Attorney General has correctly advised the executive to implement the court order. That's a good thing. However, I think that the learned Attorney General is misadvising the General Court Martial. The insinuation in the remarks of the Attorney General is that Court Martial keep holding on to these people until the DPP determines whether or not to take over this matter. I think that that's ultra-vires. Because for all of these people who are being held, Dr. Kizza Besigye, Obed Lutale, NUP political prisoners that have been held for over 4 years now, the Supreme Court said all those matters under the court martial should cease with immediacy. Now, Article 120 of our country's constitution, which provides for the office of the DPP, when you go all the way to number 6 under Article 120, it says that in the exercise of their authority, the DPP shall not be under the control or manipulation of anybody. So nobody is meant to give any order or directive to the DPP. What the learned Attorney General seems to be saying is that now the court martial is going to be directing the DPP to say, we have these matters, you take them up. That's against the law. What's meant to happen, Right Honorable Speaker, is that the court martial is meant to issue with immediacy release orders for these people, because the court martial no longer has any authority over these people. Completely release them, and then the DPP, in her choosing and in her investigations, if she determines that maybe there is any matter that's meant to come before the civilian courts, that can happen. But you see, the two courts are disjointed. Honorable, there is some information, if you'll allow, from...
In just a second, Right Honorable Leader of the Opposition, they have actually, from the communication of the Attorney General, they have actually already interfered with the independence of the DPP by telling her to go and liaise. So it is not that the DPP is not under control. They have already controlled her by telling her to go and liaise with the court martial.
Honorable, in my remaining 1 minute, I would like to cede ground to our Shadow Attorney General.
Thank you, Right Honorable Rob, and thank you, Council Segon and the Attorney General. Mr. Speaker, sir, this particular judgment falls in the category of what we call self-executing judgments. It's a judgment that should be complied with without any other process as alluded to by the Attorney General. Actually, if I were the Commissioner of Prisons, I would have released all those individuals mentioned in the judgment, including the UPDF officers undergoing trials in the General Court Martial in respect of offenses tried by civil courts. And then, as you normally do, you would arrest the people outside the prisons, take them to police, detain them for 48 hours, charge those you can, make fictitious charges against those you can, and do the like. But I think, yeah, otherwise, other than that, what is happening, Right Honorable Speaker, and the Attorney General agrees, is that all players, especially the prison warders who are detaining these people, are doing so illegally. We are literally doing so in utter disregard of the constitutional provision. So we have overthrown the Constitution. But be that as it may, Mr. Speaker, my worry is in what is actually being planned by the government. Because the information we've got is that they are now trying to come up with a bill to overturn the Supreme Court judgment. And that is the reason why the Attorney General has advised a series of procedures to be taken, which he himself knows are inherently illegal. So Mr. Attorney General, sir, my grand friend, don't put my brother Yabashisha, the Commissioner of Prisoners, into problems. Because today, after here, we will advise the affected persons to take out contempt proceedings against him as an individual. And he will not rely on our advice, because this particular judgment is self-executing and does not envisage you to advise them to do anything to the contrary. So just advise the man to release the people, send your police to arrest them outside the prison gates, and then begin the processes if you so wish.
Attorney General, let me allow Honorable
Right,
Jonathan Odur, then Attorney General. Please, Honorable Sechku, I'm the one who picks who to speak. Yeah. So, Honorable Jonathan Odur, then Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, first, I think as the Shadow Minister for Justice, I would like to convey words of acknowledgement and appreciation to the justices of the Supreme Court for coming out very clearly and boldly in delivering this judgment, which had caused great concern amongst the public and some sorts of anxiety. So I would like to thank the judiciary, the Chief Justice, and the justices who delivered this unanimous decision. Mr. Speaker, Article 126, Clause 2E, and I would like to read, says that substantive justice shall be administered without undue regard to technicalities. The learned Attorney General understands this very well. What he is trying to do is trying to delay substantive justice. The orders are as clear, and that court-martial, in my understanding, has not been disbanded. What I'd expected today or yesterday was for the court-martial to sit and say, we are now discharging all these persons that were before us, that at that time we thought we had the authority to try them. But now that court has declared, we are now discharging them. And that would be the most logical step to do. We also know that courts rely on departments and agencies and authorities of government to function. Courts do not have the force to go and pick people, just like the speaker you observed here. As Parliament, we cannot go to prisons and open those padlocks. Courts rely on the goodwill of the executive in implementing the decisions that they issue. So I expected that the Attorney General, the DPP, the Commissioner General of Prisons, whoever is involved, to comply with this. The last point I would like to ask the Attorney General. You have read to us very good advice you have rendered. I would like to know whether you rendered that advice to the President. The President quoted you, that he called you on phone, and you seem to have given him an advice that does not match with what you are telling us here. Would you now? And Mr. Speaker, this letter from the President is in the open. I don't need to go through it. But he quoted that he got in touch with the Attorney General, who explained to him certain things. I understand that the Attorney General, being a party to the suit at that time in the heat of the moment, having lost that big case, you would have lost a little bit of your composure. But would you now clarify to us? And I've ever been to the Supreme Court as a litigant, and I lost a case. I know what it feels like. So I understand what the Attorney General went through. But would the Attorney General tell us clearly if this advice that he has told us here is exactly what he rendered to the head of the state? Because what the President wrote potentially undermines the rule of law, undermines democracy, and I thought that it is incumbent upon the Attorney General to guide the President on the next course of action. Would you clarify to us and even lay, where possible, that opinion? Because this is not just advice. You said a legal opinion, and there is clarity on how a legal opinion is rendered. Would we see that here, Mr. Speaker?
Thank you, colleagues in the public gallery this afternoon. We have students from Hatumbanja Hatungbanja Child and Youth Development Center, Namayingo South County, Namayingo District. They are represented in Parliament by Honorable Wanyama Michael Dori and Honorable Makoa Margaret. They've come to observe proceedings of this House. Please join me in welcoming them. The Honorable Attorney General, narrate the
Thank you
Attorney
very
General,
much.
please. Answer some questions.
Thank you
then
very much, Right Honorable
I can
Speaker.
pick another set, okay?
Thank you very much, Right Honorable Speaker. First of all, the court martial cannot sit. So it cannot sit to make any orders that you want them to make. That's one. Number two, if there are facts that you have, Honorable Medat Segona, as a senior lawyer, if there are facts like you have stated here, the best place to take them is to the court. Yeah? Yes. Secondly, Right Honorable Speaker and Honorable colleagues, Honorable Segona should know that as a practicing advocate, after you are successful in court, you extract a decree. If you think my advice is inconsistent with what the judgment said, you should at liberty to extract a decree, have the court sign it, and use it in the premises that you would like to use it. I have read this judgment variously, and you may think that I was sleeping. I did not. I spent time reading this judgment page by page, and I word for word. And what I have advised here, I did not get from my head. I got from the judgment. The matter under discussion is not the Court of Appeal decision. The matter under discussion is the Supreme Court decision. So reference to the Court of Appeal decision, which was appealed against, is misplaced. Now, there are no timelines. I agree. But we have sent the matters to the courts which granted these orders. The courts are still clothed with the authority to make any orders that they deem appropriate. Like
Point of order.
You see, Right Honorable Speaker, when the Attorney General speaks, he's the head of the bar. Everybody at the bar ordinarily should keep quiet. I agree with him that a successful litigant goes ahead together with the losing litigant to sign a decree, to prepare a decree jointly. If he was waiting for a decree, what was the basis of his advice? Number two, I am not aware, and he can now educate us, the law under which a losing or vanquished litigant would write to court to ask for which orders. The orders, Honorable Nwagaba says, is self-executing. Is the Attorney General, therefore, in order to mislead both the House and the country that the person who was in court when the judgment was being issued is waiting for a decree extracted by one party?
Attorney General, you want to make some clarification, if I can guide?
Right Honorable Speaker, I think where we are going here is a bit of a runaround, because I have told you my understanding of the judgment. And yes, and that's why maybe I lost. But what we are saying is that if you disagree with what I have written as what the court said, the arbiter is there. Now, finally, Right Honorable Speaker.
Procedure, Honorable Seshkuba. Procedure.
Thank you very much, Right Honorable Speaker and members. Right Honorable Speaker, as a law student and a practitioner, the basic principle we are taught and we learn and we practice is that judgments of court, particularly the Supreme Court, are judgments in rem. They are not in personam. meaning that all must abide not only the Attorney General, but the constitutional order in the country must listen and adhere. So, number two, the Land Attorney General, Right Honourable Speaker, did his best when he made arguments before the Supreme Court. He did his best. That is the best he could offer. Now for this House to demand and to expect a better alternative from him, I think would be too much. That is the best he could offer. He stayed the Constitutional Court order. He ran to the Supreme Court, prepared himself, robed himself, got all his entourage with wheels and cattle. He proceeded to the Supreme Court. Unfortunately, he couldn't do better than he did in the Constitutional Court.
What is the
To that regard, Right Honourable Speaker.
I need the procedure matter.
Yes. For this House to expect a procedural guidance from the Land Attorney General, when he had failed to convince the 7 justices of the Supreme Court, Mr. Speaker, sir, would be a big disservice, not only to this country, but to Parliament. And lastly, Mr. Speaker, I listened in very well. Once you talk about the Constitution, it is the paramount and the fundamental law we have. In his statement, I heard him say that the DPP, the Director of Public Prosecutions, should liaise with the General Court Martial to get files and process those files. Right, Honourable Speaker, for purposes of record and the Hansard of this House, Article 120 of the Constitution is the Director of Public Prosecutions. And Clause 6 states, in the exercise of the functions conferred on him or her by this article, the Director of Public Prosecutions shall not be subject to the direction or control of any person or authority. By the Land Attorney General telling the DPP to go and liaise with the General Court Martial is in total breach of this Constitution. And I would therefore like to say that his guidance, even now, is continuing to offend this Constitution. And therefore, I would pray that we give him leave so that he can rest, he can think about the events of this country, he can choose whether he wants to take the country to the constitutional path or he wants to take this country in the dark times, and without any delay, comply with the Constitution, with the Supreme Court orders, and release these persons detained, so that now the country can breathe a sigh of relief. Without that, whatever explanation is talking about, he's wasting the time of this House and is continuing to agonize the constitutional order of this country. And I pray that anymore, Mr.